Assalamu alaikum. In this video, I will discuss asylum case. This case was between Colombia and Peru. Colombia versus Peru. The brief fact of this case was the Colombian ambassador in Peru grant asylum to a political leader accused of having instigated or excited a military rebellion, whose name was Victor Raul Hayatillatorre. Both the Peru and Colombia agreed to submit this accused Raul Hayatillatorre, Victor Raul Hayatillatorre, to submit to the court. Uh, Colombian ambassador granted him a political asylum. Colombian government claimed that they have such a right to grant political asylum according to various convent or various international agreement treaties such as the Bolivian Agreement of 1911 on extradition, then the Havana Convention of 1928 on asylum, then Montevideo Convention of 1933 on political asylum, and also according to American international law. Okay, it was also claimed by the Colombia that they have such a right to grant political asylum under local custom also. Okay, but Peru refused their claim. They doesn't agree to grant the accused Victor Raul Hayatilla safe passage in Peru. Okay, the uh, ambassador is considered a sovereign institute because an ambassador represent a sovereign country, so it's also considered as a sovereign institute. As it's a sovereign institute, Peru thought that whenever the accused Victor Raul Hayatillatorre will leave this embassy and come out from this embassy and try to leave Peru or move into the Peru, they will uh, arrest him. Okay, the issue of this case was, can the Colombian government offer asylum under local custom and the treaties? The decision was in favor of Peru. That's mean against the Colombia, because whenever Colombia claimed that they have such a right to grant a political asylum based on various international treaty such as the Bolivian Agreement, Havana Convention, and Montevideo Convention, and other international law, then Peru disproved their claim. Peru rejected their claim by the argument that uh, Peru said that uh, they have not ratified, they have no consent to those convention which was mentioned by the Colombia. So this agreement, this convention were not bound on Peru, so they cannot grant political asylum on the basis of this agreement. Okay, whenever it was disproved that the uh, that Colombia is unable to grant political asylum based on above mentions international treaty, they raise another argument that they have such a right to grant political asylum under local custom. But unfortunately, this logic, this argument is also disproved because they unable to prove that the local custom was bound, the local custom was become binding on the other party. Uh, Local custom may be an international source of international public international law, but those who claimed it must prove that it is also binding on the other party. That means Colombia uh, must prove that this custom is also binding on the uh, Peru, but they failed to prove it. So the decision was in favor of Peru and against the Colombian government, Colombian ambassador. The principle of this case was custom as a source of international law, but to establish a local custom as international law, it must be proved that such a custom is accepted generally and practiced generally, and this custom must be accepted uh, voluntarily, and people must believe it as a law. Okay, custom must be practiced from long time or from time immemorial, or it must be ancient, and opinio iuris. It means custom must be accepted by the people voluntarily, or people believe the custom as law. Okay, it's opinio iuris. It's a psychological element, or subjective element, and practice from long time or from immemorial time, or from ancient time. It is objective element of a custom. To be a international law, custom must fulfill these two element. Okay, I think you have enjoyed this video. If you understand and if you have acquired any knowledge from this video, please don't forget to subscribe my channel. Thank you.